So very good morning, all of you. Today, just we are discussing about that the funding possibility of patent in KAPILA, and KAPILA is that Kalam program for the IP literacy and awareness. So I hope that that is the very good initiative from the government of India for just change in the pattern of patent, because nowadays the patent number of patents in India is very less compared to the world. So just that is the initiative of the government of India, that how we can aggressively just go for the patent basically. So first of all, just before that, because we know that most of the persons, because here also some students also, so they don't know about the patents. Sometimes a patent, patent we think about that something which is very innovative, something which very new, and sometimes we think that that is not possible from our side. So this is the thing actually. So first of all, I will just clear about what is a patent basically, because that is the fundamental things, and after that we will discuss more. So normally we heard this term, this intellectual property rights, and then patent. Sometimes maybe the students, maybe the new teachers confused about the what is the IP and what is the patent. So just I want to clear first of all definition, then we can go exactly for the what is the planning of the government of India as a KAPILA promoting the patent. Okay. So this IP is any creations of human mind, like tangible property. Their creation has a value, as with all property, it needs to be protected. So here first word came, that is the intellectual property. Intellectual property means something which is generated by your own mind, something by your thinking, something by your research. So here intellectual property, just like your maybe your money, okay, maybe the other things, maybe the gold, like that. Here also the term is that intellectual property means something which is very unique with you, okay. And another thing is that it needs to be protected, because maybe my thinking is very good and I am just maybe I invented something, but maybe possible that is not useful for the human beings, so it needs not to be protected. But if you invented as a by your human mind, by your knowledge, something which is very unique and something commercial value, so that is basically intellectual property. Here the things should be very clear. The intellectual property is the different and intellectual property rights is different. So that is IPR. So IPR gives them this protection as well as helping them exploit and control their IP. Suppose if you have some house and if you have no registry about this house is also in property, but if it is not registered with the government, then what will happen? You cannot be sell this property. Understand? So same like that, here intellectual property means something you have which is unique, which is very new, which is the results of your research, and you needs to be protected. And you sometimes you want to sell also. So first, for the sale, you need something power, you need something right on this particular property. So here this name is that intellectual property right. And now today we are discussing about that, how we can get this intellectual property right. And patent is the way by which we can get this intellectual property rights. So what is IP? IP are basically the exclusive right granted by the state to prevent others from using, manufacturing, distributing inventions, processes, applications, new and original designs, trademarks, new plant variety, something like that. Anything which is very new, which is very unique, which is the results of your own thinking process. So the state government here means, state means that is the government basically. So government just give you something right for protect this. So basically that is known as the intellectual property right. So here sometimes another confusion is that sometimes we think that patent means something one thing actually. So here I want to show that something these types of IPRs, because IPR not a single type. I mean sometimes we think that if just something which is in academic field, something which is in any industry, so this is the IPR. No, IPR has many types. So here you can see that first thing is that is the industrial designs. So industrial designs is very essential part of the IPR. I think you know that there are different types of bottles, like Bisleri bottles you've seen. Okay, so maybe in Bisleri bottle, the colors combinations, maybe the shape of the bottle, maybe the size of bottle is the unique. Understand? Here you can see that this is the Coca-Cola bottle. So this bottle is the basically that is the trademark. This bottle is the something that is a brand basically. So what we need, first of all, we need to industrial designs. So designs is not limited to the bottles like that. So anything like chairs also. If you will see the Neel Kamal chairs, okay. So what that is a branded chairs. So the branded chairs is not available into the any local houses. So here you can understand that first of all industrial designs. So if I will tell in the respect of the Medicaps University, so suppose if you are invented something experiment, okay, and you need to set up some experimental setup in the laboratory. So what will happen? Your experimental setup, suppose this setup, then also you can go for the industrial designs. That is the one thing. Second thing, that is the patents. So we will discuss one by one like that. Third thing, that the trademark. Trademark means we know that here just this is Coca-Cola, that is the trademark basically. Okay, here also the trade secrets also. Trade secrets is not related to the academic, but what happens? Suppose I think you know that. Suppose that is the about this Maggi masala. Okay, so Maggi masala is something unique. Okay, like also same like that. That is a Coca-Cola and that is the Pepsi. So the formula Pepsi, the formula Coca-Cola is also the trade secrets. So here, which is something which is very important to your business and base of your business, and you don't want to show to the public and you need to protect it. So that is also comes into the trade secrets. Then another things come, that is the geographical indications. So what is the geographical indications? I hope you know about the Mathura ke pede. Okay, and this rasgulla from Bengal. Okay, sometimes Kolhapuri chadar and Sholapuri chappal like that. So you know that something which is related to the specific geographical locations. So sometimes what happens, this geographical indication is also the patented. I think you remember that previously that was the fight between the US and India about the neem patent, because neem is the basically the USA claim that the the US want to patent the neem exactly, but neem we are using the neem from last ancient years. So that is the geographic indications is also important. Then another thing is that is the layout designs of semiconductor ICs. Semiconductor, now we know that everything is just IC based actually. So here IC design is also can be go for the industrial property and can also go for the patent. Then that is the plant varieties. Plant varieties, we know that now different types of agriculture crops are going on. Like you heard about that, like BT cotton. Okay, so there are several types of plant varieties. So normally what happened, this type of varieties normally developed by the government also and as well as the private industries also. So this is also can be go for the patent. So here you can see that there are the different types of patents. We can go for the different type of patents. Another thing is that is the copyright and related rights. So I know you also know about the copyrights, because sometimes whenever we see any book, then on the first page of the book you can see that is the copyright protected. So in copyright protected means just you cannot be copy from this book. So this is the basically types of IPRs. So I hope you understand that IPR doesn't mean that only the patent. Each and everything which have some commercial value actually. Okay, so it can be go for the patent. So here you can see that types of IPRs. So now we can see that exactly what is the definition of these things. So first of all, industrial design. So as we discussed about this, industrial designs means features, shape, pattern applied to the article by an industrial process, manual or mechanical. Like chair, I given the example of Neel Kamal chair also. Okay, so here you can see that chair itself doesn't qualify for IPR. Suppose if you go into the patent office and if you want to do the patent of the chair, so that is not possible. Understand? But what will happen if you will go for the special shape, special pattern of the particular chair, then you can go for the industrial designs. So how that is useful for our academic faculty also? Because what happens, suppose you are doing some experiment and you change into the normal experimental setup, so you can go for the industrial design. Like in chemistry, physics also, suppose if you invented new experimental setup, which is very useful for the students, and you can show the different laws easily, so that you can also go for the industrial design. So industrial design doesn't mean that you have required to specific knowledge or a specific particular related field. Something which is very unique, you can go for the patent. Second thing is that is the patents. Okay, so that is a very important issue now. That is the burning issues in academic field, because in everywhere we need to the patent basically. So basically, patent is the monopoly right granted to a person who invented a new product or process of making an article for 20 years under the Indian Patent Act, and it can be renewed after the expiration of the period. So here you can see that different types of maybe machines, maybe something which is very unique, you are changing in the process, you are changing in the instruments, so it can be go for the patent. So normally what happens here, the things is that something uniqueness is needed. So uniqueness, it doesn't mean that you need to generate or you need to invent 100% new. If you are just innovative something with 10% in the existing things, so also it can be go for the patent. Understand? So here what will happen in patent, you can see that different types of claims are there, means how much the uniqueness in your patent. Understand? Then trademarks. So as we discussed about the trademark, so trademarks can be the word, name, brand, symbol, label, something which is useful for your business, okay, which is creating the brand name in the media and in the social. So it is the basically trademark. So here you can see that industrial design, patent, and trademarks. Okay. Trade secrets, as we discussed that, trade secret means something which is very, very important for your business. And if this trade secret will be leak, then what will happen? It will be adverse effect on your business. So that is in the trade secrets. I given the example of like Maggi masala, Coca-Cola, Pepsi, something which is something. Sometimes what happen in pharmaceuticals also. Okay, so that is a trade secrets. Geographical indications, like I given the example, Nirmal paintings, Kolhapuri chappal, Sholapuri chaddar, Mathura ke pede, Rasgulla. Okay, here also in Indore, if you get the Indori Sev, now that is not patented, but that is also geographical indications. So what will happen in geographical indications? Normally what happens, the people not go for the patent. Normally the government, suppose if I wanted to just patent Indori Sev, so I cannot be patented. Maybe the government of MP or maybe the suppose association of Indore will go for this geographical indications. And what is basically advantage of that? Because in whole world, anywhere we can sell our Indore Sev. So it will be the brand basically. So that is the advantage of the geographical indication. Again, thing is that is the copyright. That is a very normal things. Copyright, it is a negative right. Okay, here you try to understand negative right, which prevents the appropriation of the fruits of man's work, labor, or skill by another person. So copyright, I hope everybody understand that. So if you have written some book, if you have written some poem, then what will happen? It cannot be copied without your permission. So that is basically the copyright. Okay. So here also I want to clear one thing for the faculty member. Copyright doesn't mean if you will something writing the poem, if you are writing the book. Copyright means something, suppose if you are writing some article about your experiment, about your research, maybe any short note, so you can also go for the copyright. Okay, copyright may be related to your research field also. So here copyright also related to the academic field. So here that is the industrial design definition basically. So a design refers to the features of shape, configuration, pattern, ornamentations, or compositions of lines, colors applied to any article in 2 or 3 dimensions. So any design, okay, that is my suggestion for everybody. Suppose if you are doing some changes in your experimental setup, which is already available in laboratory, so we don't need to fabricate or we don't need to manufacture that. Suppose if you are just on the drawing sheet, if you are just to prepare the drawing, so you can go for the industrial design patents. Next thing is that in patent also, just patent is also not the one type like that. First of all, that is utility patent. So whoever invents or discovers any new or useful process, machine, manufacture, or composition of matter or any new and useful improvement thereof may obtain a patent, therefore subject to the condition and requirement of the title. Title means, suppose if you are just suppose I am from the mechanical field and sir, I will just I wanted to go for patent for modification in the 4-stroke engine. Okay, so in the modification of 4-stroke engine, so I need to give the exactly design. We need to give the brief about this process. We need to what we exactly change, what is the novelty in my work. So everything which will be go, so it will becomes into the utility patent. Utility patent means something is uniqueness or something is new which can be used for the any manufacturing process. So that is the basically utility patent. So utility patent is a very broad term. It is not under the any machine. I mean, you cannot be related only with the any machine, only with the any process by which idea, by which any discovery, by which any new things which can be helpful for converting into the product. So it will becomes under the category of the utility patent. Plant patent here also, in our university also this agriculture department. So suppose if you are just by the seeding, okay, by the hybrid of the 2 different types of seeds, if you are developing something new, so that is also going to go for the plant patent. So I know, maybe you know about this, like now this wheat, like Lok 1, like 147. So there are different varieties of wheat. So these varieties also the patented basically. Okay, design patent also I told about you that. So whoever invents any new, original and ornamental design for an article of manufacture may obtain a patent. Okay, so everything which can be created into the product, which can be sold into the market with some commercial value. So this type of things can be go for the patent. So what is the, sometimes also that is a normal question from the student side, normal question from the faculty side. What we need exactly for patent? Because what will happen, everybody cannot believe that I invented something and it can be patented. Okay, it was very difficult previously because at the time that was very costly. Government not normally support for the patent, but now what is happening, everybody is supporting for the patent. Understand? So here now this, if you are any idea, if you are any new machines, if your modification change is a new product or process, useful and capable of industrial application. Capable of industrial application, it means that your things can be changed into the product. Okay, not only the your idea, because something which is you are invented, something you are thinking, a result of thinking, something you are innovative things which can be capable of industrial application in any way. Okay, means you are improving these things. Suppose improving the surface quality, you are improving the texture. Okay, so something which is with the uniqueness, if it is capable of industrial application, it can be converted into the patent. Second thing is that anything, okay, please take my word, anything, if you are thinking, it can be converted into the industrial applications. Obviously, because everything is in the sale into the market, and something which is related to the agriculture, something which is related to the pharmacy, engineering, physics, chemistry, English, something which you are doing, it can be converted into the industrial application. So everything is patentable. So, but the important thing is that is the novelty. So what is the novelty? Novelty is an invention, depends upon the state of prior art, the existing knowledge and similar inventions already known in the particular field. Because we know that now in India, now we are around 20 years behind of US, UK, okay, in the field of research basically. Because we have no any, new technology, sometimes also facility. Okay, so what will happen? Suppose if we are just inventing here something, then may be possible that is already invented. So what will happen here? Novelty is very important. Maybe the novelty, maybe the 10% novelty, maybe the 5%, but something should be uniqueness in your work. You cannot be just copy from others and just you cannot go for the patent. Because here the one thing, that is a search report. Search report means like in also the plagiarism. Suppose if you are writing from the copy, then it will go into the software and it just software will tell, okay, this you are taken from this. Here also the same thing will be happen. If you are just going for the patent office, then what will happen? whenever the patent office will be go for the searching, then he can tell you this you are just trying to patent, but that is already patented and patent is granted. Okay, they can show also the patent number also. So something uniqueness is needed in your work, but I am telling that you can create some uniqueness in your work. Okay, uniqueness means which is not in already existence. So that is the basic need of the patent. So persons entitled to apply for the patent, persons claiming to be the true and the first inventor of the invention. First inventor, it doesn't mean that like in our research publication, first author, second author. First inventor means you are the new and you are the first person who are going for the claiming this innovation. So any persons being the assignee of the true and first inventor of the inventions. So suppose if I am Ravindra Pathak, I assign to the XYZ for patenting, then this person also can be patented by the legal representative. So suppose if I am giving the right to the lawyer, then lawyer also can go for the patent. So another thing is that there is the full disclosure of invention. Whenever you will go for the patent, then that is the very much requirement of patent file is that you have to give the full disclosure. On the basis of that, the patent office will be search about this patent. He can the search about the literature also, the previous patents also, and if they will found some uniqueness in your work, then only they will give you the patent. So here also, what is the patent protect inventions? You need a patent. When you need the patent, okay, not for the academic requirement. Suppose if you have invented a product, you want to market yourself or sell to the manufacturer. Of course, if you have created something new which can be sellable into the market, so you should go for the patent. Then you believe someone else could sell the product by copying your invention. Sometimes what happened, we just created and we are selling into the market, but after some time we realize that maybe my neighbor can be copies these things and can be sold again in market. So at the time also we need to the patent. Okay, then what is the need of the patent applications? So patent application, we need to in-depth description of invention. So how it can become? Whenever you will involve very much into the patent, you know about each and everything, then only you can give the in-depth descriptions. So as I given the example is that, suppose if you are changing into the experiment, if you are doing for your research work, PhD work, your MTech work, so at the time, we know that we are creating something new, which is not done by the others. So we can give the in-depth descriptions. Drawing of invention, that is also important. Drawing doesn't mean that you need to create on the just AutoCAD and KT or something like that. Drawing in the sense, maybe drawing sometimes, if you will see into the different patterns, the drawing may be the freehand also. But what the need exactly need is that your drawing should be very much clear, okay, and it should be help with the description of your invention. Declaration of the patent application, of course, declaration we need. Notarized statement from the inventor and filling fee to patent and trademark office. So we need to one fee, we need one lawyer, okay. And here also sometimes we don't need lawyer, just we can go for the website and just we can fill the patent also. That is also now possible. But what will happen? That is a legal issue. We don't know actually what are the precautions we need sometimes. So we need to the one this attorney also basically. So here I given the one example, actually maybe I did it visible or not. So I think you remember that yesterday our honorable vice chancellor sir told into the meeting is that now the patent we need to name of applicant on the university. So I hope here you can see that in that paper here this name of applicant, okay, name of applicant. So here our Medicaps university will become. So it means that the research facility and everything is just we are using the source of the Medicaps university, though Medicaps university is the applicant and we are the inventor. Something I invented XYZ, so XYZ is just invented by me, but my patent is filing by the Medicaps university. So here the name of applicant will become into the Medicaps university. That is a new thing, because what will happen previously, this institutional, if you wanted to fill the institutional patent, then it was very costly. Now the government want that educational promote to educational institute for filling the patent. So here you can see that here name of applicant, that is the Medicaps university, and here is the name of inventor XYZ. So here now this is the we need for different ranking purpose. And that was the problem with us also, because last time what will happen, we have around more than 15 patents, but what will happen, every patent was the individual patent and maybe the affiliation name of the university, but what will happen, the name of applicant was also the individual name. So that was the problem. And now just we are, I think you remember that the last yesterday vice chancellor told that now the applicant will be the Medicaps University, and it will be useful for the your also, for your purpose also, and for the university purpose also. Here also I want to show that that is the, I mean, what is the basically that patent is published basically. Okay, so here I am showing, it doesn't mean that I want to advise myself, but I want to show that because this patent is drafted by me also, so I know about the each and everything into this patent. So I am showing this patent. So here I am just wanted to give the example. Here I prepared a dustbin system for recycling of plastic waste into the fuel using pyrolysis process. So here maybe from the chemical field, so they know about the pyrolysis process. So here what I have done, I prepared one prototype of the dustbin, and in this dustbin I just use the pyrolysis process, and pyrolysis process is already, I mean, patented. That is not a uniqueness. But what I have done, I used pyrolysis process as a dustbin systems for recycling of plastic waste. Okay, so what is my uniqueness? My uniqueness is that I used pyrolysis process for dustbin making. So this is the title of invention. And here application type, that is the ordinary applications, means that is a simple application. Okay, not the design something like that. So here, and here applicant name, you can see that here the 5 name is there. And what is the beauty in the patent? Suppose if you are the first inventor or 6th or 7th, because sometimes what happened here, some cost is also involved. So we need to 4 or 5 people, so just we can share the cost also. So here each and every person, suppose first to 5th person, everybody will be get the same advantage. Means here not like in research publication first author, second author. Here everybody will be the inventor. And if you will go for the API score, then what will happen? You can get the same marks first to 5th. So that is the beauty of invent and patent, and everybody can get the same benefited. So here that is the patent which is published. Okay. So first of all, you have to clear the things. Clear the things means, suppose I have some idea and I go for the attorney and I just fill the patent. So what will happen? The first step is that I got the publish of the patent. Publish of patent means now this patent is available to the public. Available to the public means anybody can be claimed that this patent is of mine. Okay. Second thing is that now this things is not, that is not granted to me. Understand the difference between grant and publish. Publish means that is showing for public that Dr. Ravindra Pathak is going for this patent. So it is published into the market. That publish is the one thing. And grant means now everything is finished. The patent office is checked everything, and now the patent office is satisfied with your invention. And after that, the patent office will be grant. Understand? So now this patent is not grant, that is the published to the society. So it takes maybe the 1 year, 1.5 years for grant basically. So if I will tell in the academic terminology, patent publish is, I mean, less weightage, and if you are got the grant of the patent, then it takes the more value. So I hope you understand the difference between the published, patent is published, and patent is grant. Grant means after whole process, the patent office is got that your I mean invention is very unique, and if he will give the rights to you, then it means that your patent is grant. So here also I am giving the one example. So previously patent was the published, and this is another patent, that is not the same patent. So here also you can see that now I got the patent number. Okay, and here date of file. Okay, and now you can see that here name of the patentee. So here it means that now my all work is verified by the patent office, and this patent certificate, it means that here you can see that also this is term for 20 years. So now you can see that this patent is granted to me. Okay, and previous patent was published into the market. Okay, and after that, after all, because what will happen, it will be investigated by the patent office. Okay, we need to pay some fees for investigation, and after the investigation, if they will feel that okay, this patent is good and a patent can be go for the granting process, so after that you can get the grant. And this is the ultimate, I mean, say, if you will get the patent certificate, it means that is in that is a patent of you, and you can sell into the market basically. Okay, so I want to just things should be clear about the publish and patent, because what will happen, somebody will be think that okay, patent will be published, it means grant. No, maybe possible whenever you go for the search report, then the patent can be cancelled also. Here also I want to show the this one patent, that is the now these things is going into the, that is the Australian government also. So in Australian government, what they are doing, they are not publishing the patent, they are just checking. Suppose if we feel the patent, then what will happen, they check, and after that they just grant the patent. So in the Australia, that is not a process of the publishing. Normally you can grant. Here just received, I received on the 17th of November only. So here you can see that that is the certificate of grant. Okay, so that is by the Australian government basically. So what is the pathway of the patent? Now I hope you clear the terminology. I mean, suppose if you will tell publish my patent means you filed the patent, it is in process. If you got the patent grant, it means you got the rights of your patent. Okay, so here this is the pathway of a patent. So first of all, file a disclosure document. Okay, and establish date of concession idea. Okay, sometimes what will happen, suppose if I am starting the work on particular thing, and maybe these things is very unique, but I am also don't know about that. That is also possible, because I am started working on particular XYZ things, and I am also don't aware about this. Then what I will do, I will go with this idea for the patent that I am working on that. Okay, and then I will get a 2 years grace period. Means after 2 years I can update this patent also. So this is also facility into the patent office. Then that is the provisional patent. Provisional patent means what will happen, that is the patent is pending. Just I published the patent, basically that is the provisional patent applications. I'm just apply for the patent. And non-provisional means file complete description with the PTO, patent and trademark office, and patent applied for. So here also the things is there. Suppose if you have idea, you don't know about that, but you want to protect this idea also, that you can go for the patent also. There are different types of application process also. Now, I hope that everything is clear for you. I mean, what is the patent and what is things. So I just revise this thing also. So first of all, you need some idea. Then you have to prepare some abstract of your idea, like in research paper also. Then you need to description. Then you need to some diagrams. And now the things is, go for the attorney. Attorney means lawyer who created into the legal form basically. Okay. Here the role of attorney is like that. Suppose if you want to the register of any property, register means that is a house, suppose. So you will give the information about your name, Aadhaar card, something like that, and details of the registry, details of your house. Then he will just prepare the legal document. Legal document means he will according to the rules, and information will be same. Whatever the information will be given to you, suppose. So then information will be same. Only the drafting process will be the done by the this lawyer. Here also things is there. You will give each and every information to the lawyer, and lawyer will be draft according to the legal requirement. And if you are capable for doing that, then it's okay. You don't need to the lawyer. So here that is the KAPILA. So what is the KAPILA? So KAPILA is the Kalam program for IP literacy and awareness. Now I previously told that now the government is very aggressively working for the patent, because what will happen in the whole world now, China and US leader in the patent. Then what will happen? This patent will be sometimes what happens. Suppose if you are doing something new and you are selling, your shop is very good, you are working very good in business, and after that one MNC will be come from the US. Understand? And maybe this US company will be see your product, and if this company will show the patent document, then what will happen? Maybe you need to close your business. So now you understand the importance of patent. Before that, what will happen? Before our liberalization, the things will be closed. Okay, we know that here in India everything was going on, but what will happen now? That is the open economy. Everybody can become in your country. So at that time, the importance of this patent is very important. So now the government is just promoting this basically. So that is the scheme. This scheme provides financial assistance to the institutions that are part of higher education, HEI basically, for filling patent. So now what is government doing? Government is doing that if you are just filing your patent, then also the patent fees is needed. So this patent fees will be paid by the government. So that is basically KAPILA. Kalam program for IP literacy and awareness, which will create appropriate awareness regarding the need of IP filling mechanism and methodology involved in the filling IP in India and globally, especially amongst students and faculty of. So this scheme is for students and faculty of student engineering, sorry, not engineering, that is the whole education institutions. So this is the scheme of the government basically. So I hope you understand that the government wanted to support in the filling of the applications. So what is the objective of this KAPILA? The objective of this KAPILA is to recognize, facilitate, and the intellectual property, innovation, and the best practices in HEI. So I want to clear that this KAPILA is basically will be help to the any IP cell. Suppose in medical university we have the IP cell, then what will happen? All the works will be done through the IP cell. So if you will just contact to the IP cell, then you can go apply for the KAPILA program. So KAPILA will help in establishing the much required IP filling ecosystem in the large number of education institutions, and thus create a culture of systematically protecting new ideas, research and innovations having national and global relevance. Now you know that in the field of this IT, suppose if you are generating some idea, then it can be just shared by the another person and it can be reached within 2 minutes in any part of the world. Then what will happen? Any person can be copy your idea, any copy of your research, and if he patented, then right will be this person. So now the government is taking very seriously about the innovations of students and faculty members, and by these schemes the government wants to help to each and every persons of the higher educational institutes. So what is the expected outcomes from government? So first of all, awareness. Obviously, just we are discussing about this KAPILA scheme. It means just I am also creating the awareness between you. So awareness creations regarding the need of IP filling mechanism, methodology involved in filling IP and globally means what will happen whenever your a patent will be approved into India, then it will go for the Switzerland. So now I forget actually, otherwise I will show into the Switzerland website also, the name will become of yours with your patent. And then establishing the much required IP filling ecosystems in large, okay, and creating a culture basically. Basically, government wants that maybe the in 100 ideas, 10 to 15 ideas was very creative. So government want to protect these ideas. And program will be set foundation for institutes participation in the MOE, innovations and entrepreneurship initiatives such as IIC and RI. So here, the government basically wanted to promote through the different platforms. I think everybody knows that Innovation Institution Council and ARIA ranking, everybody knows that. So here the government initiative is that how can we promote the students and faculties for filling the patent. And another expected is that strengthening the connection of institutions located in Himalaya, northeastern regions. Okay, so here also we want to create a connection between the institutes. And active participations and involvement of student, faculties, and staff, basically. So here the whole thing is that how we can increase the number of patents filed by the government, filed by the different education institutes. So filing at least 10,000 patents applications per year from the institution sides. So that is the objective of this scheme. So what is the application process methodology? Because that is very important. So first of all, online submission of shortlisted application details, title of patent we need to, date of patent, filling, applicant, okay, by the institute through the KAPILA portal. So here the thing is very important, and maybe I can say that is the negative point of that. So in that case, first of all, you need to just fill the application. You need to fill the patent, and after that, this with the copy of receipt, if you will go for the KAPILA and you will apply the KAPILA, then by the KAPILA scheme, you can get the reimbursement of this amount. Okay. Then scrutiny of the submitted application to check for correctness of data at the institute level. So I obviously told that is the nodal agency will be the IP cell, or that is the MISC of the university, and government will just coordinate it through the university with you. So what is the your work is that you have to submit the application to the institute, and institute will be forward to the KAPILA basically. The final decision will be taken by the MOEs, innovation cells, keeping in view the expert committee's recommendation and the availability of funds for the schemes. Here also, for each institute, some funds actually that they are not giving unlimited basically. So there are something numbers for the each and every institutions. And here also the expert committee's recommendations. Expert committee's recommendation that is not from the national level. Normally in the university also we have to create one expert committee, and with the recommendation of the this expert committee, this institute can be forwarded to the government of India. And after the MIC approval, the total sanction grant will be sent to the institute on reimbursement mode. So I hope you understand that. So first of all, you need to just file the patent. And after the file the patent, you will come with the all documents and the receipt of your fees, and then through the institute, we will apply to the KAPILA scheme. Here, the important thing is that what are the funding possibilities here? So here you can see that the funding support for patent application fee 1600. So this is the fee which we need to filling the patent. So if you will open the website of the IPR also, then you can see that here you can see that is very nominal fees for the patent 1600. Now also the revised fees maybe the less than 1600. I should not remember that, but 1600 was the from last 10 years. Just we are seeing the same fees. So this fees. Then second thing is that request the examinations fees. As I told that, suppose if you are just prepare some patent, and if you are applied for that, then what will happen? First of all, it will go for publish. Publish, it means that is available for public and anybody can be seen your patents. That is the stage of the publish of your patent. Then what will happen? You will go for the request for examinations. Examinations in what way? Examination is in the way that this patent office will be searched that what is the validity of your patent, and just like plagiarism, he will check the plagiarism of your patent. If it already done by another person, then obviously it will be refused. Okay. Otherwise, and if they will get that, okay, something uniqueness in your patent, then it will go for the patent. So that is known as the, sometimes it's called also search report. And here you can see that is the examination fees, that is around 4,000 basically. So amount per application, that is the 5,600. So if you will fill the patent, then what will happen? This 5,600 you can get reimbursed from the this by the KAPILA through the government, and the money will be come into the institution account, and then the institute will be reimbursed to you. Here also that is one restriction, that is the total amount, means from one academic year the 10 applications can be considered from the one institute. So total amount in the KAPILA scheme for the institutions, that is the 56,000. So here the things should be remembered. Maximum funding amount, that is 5,600 per applications. Maximum application 10 per student. Maximum funding per student amount 56,000. So here is the one page I want to tell that. Here the fee of attorney is not included. Understand? Here all these fees is taken by the government. So basically this is 4,000 also payable in the online portal. 1,600 is also we need to pay the portal. Okay. So because what will happen now, government is thinking that the attorney is not very important, because if you are doing something new, okay, and uniqueness, and if you can file by yourself also, so it is also acceptable. So by this scheme, if you will just fill any patent, then you can get the reimbursement of the 5,600. So what is the disbursement of the funds? So maximum 50% of shortlisted application will be funded on the reimbursement mode after submitting the receipt of the patent application, filling fees and examination fees. Okay. So here also maximum is 10, but 50%. Suppose more than 10, then what will happen? 50% of the shortlist application will be applicable for that. 100% of the sanctioned amount will be released as a grant in aid to the head of institute. The granting institution shall observe all financial norms and guidelines as prescribed by the AHT. Of course, that is the thing. So here, that is the whole things of the KAPILA scheme. So I will just recall the points so you can remember, and maybe it will be useful for you. First of all, you have remembered that patent doesn't mean that only the one things are, that is 100% uniqueness. If in your work only the 10% of the uniqueness, then you can go for the patent. And patent doesn't mean that you are just creating something machine, something very big thing. No. In a modification, in the any small things also. I'm just giving the example of one textile industry. In textile industry, that is lots of water consumption. Okay, and by the any process, by the any chemical, suppose if you are reducing the amount of water which is used into the textile process, then also you can go for the patent also. So everything can be go for the patent. First of all, you have to understand this patent. Second thing is the design. Design means something, if you are creating the experimental setup, something your machine here, the condition is that you don't need to create things. You need only the design. And this design grant is very easily than the patent. Okay, if you will go for the design patent, it is because what will happen? Suppose you created the one bottle, design of the bottle. Then what will happen? The design of bottle have no, I mean, patent issue basically normally. Patent issue means that is not very fundamental issue. So what will happen? Normally they will check with the bottle patents and they will just award the grant the patent to you. So design patent is easier than utility patent. Okay, I hope these two things understand. Third thing is publish of any patent. Publish of in patent means you just filled the application, you applied on the online portal. Then what will happen? This patent is available for the public and anybody can be see your patent, anybody can be comment on your patent. Okay, suppose that is a violation of any patent. Then after that, the patent will be go for the examination. That is a search report will be generated. And if the patent office will be get the information, okay, everything will be right, then your patent will be go into the grant position. Okay, so first of all, you have to require fill the application, publish the patent, and final stage is that granting of the publication. So these are the three stages. Where is the KAPILA exist? KAPILA means, suppose if you are just filled your patent, you bought the receipt from maybe the portal, then with this receipt and with this patent, you will apply in the KAPILA scheme, okay, through the institutions. Then what will happen? If your application will be found suitable, and that is the first 10 application, then you will get the reimbursement of the 5,600 each applications. And that is only the fees which is required for filling the patent. Okay, but now what happened? If you will see into the market, sometimes also you got any messages that like sometimes they need 10,000, 20,000, 15,000. So no, this is not the fee for publishing the patent. This is the sometimes fees of the attorney. Attorney means that is a lawyer basically. So in one case, you can hire the lawyer, which is the fees, maybe the 200 and maybe the 20,000. So you can understand that that is the, I mean, fees variation of the lawyer. That is not the fee of the patent. So if you will go for the filling the patent, then it will be, I mean, free, because in KAPILA now in our university in the whole year, just we fill the patent maybe 10, maximum 10 like that. So these 10 patents also can be we can get the benefit from the government. So this KAPILA scheme is very useful for faculty members, because something you are new in this field and maybe you are going for the first patent. Then my advice is that just summarize your work into some format. I will also forward some formats also which is required for applications. And here also the website of KAPILA, kapila.mic.in. So you can find out each and every information on that. And only thing is that you have to require through the institution or through the university. Okay, so thank you very much. So now any question is that, then we can take the question. So that is, I mean, I want to actually communicate about that. So suppose if you think that what are the problem with the patents, and if you have some doubt, then
we can take one more because we are running short of time.
Ma'am, your voice is not clear.
हेलो, अभी क्लियर है सर?
Yes ma'am, yes.
मैं ये कह रही हूँ, अगर किसी का क्वेश्चन है तो हम एक या दो क्वेश्चन ले सकते हैं, क्योंकि we are running out of time and we have to close the session. So anybody is having any question, they may raise their hand. I have posted a feedback link in the chat box. So all are requested to fill the feedback form to get the e-certificate. So kindly fill the form. Yes, Dimple.
To ask that, like for any kind of patent, like if somebody is working on that, and recently one of the professor published his patent, Safadar sir. So like can we work under, as a student we can't go for research in our second or third year of our graduation. So like can we work under some person like professors or somebody in his to assist him or her in his work?
Okay. What is your background? Are you a student?
Yes,
Sir,
yes, sir. She is a
I'm from
student.
BTech Computer Science
Okay.
second year BTech.
Okay. So first of all, thank you very
Yes,
much
sir.
for your question. And first of all, you should clear in your mind the students are more innovative than professor. Okay, because we are here only and just like you are the river actually. Okay, you will go very far away and just we will be stagnated on this particular place. So the students in from the 10th 12th, you are the more innovative than from the faculty members. You don't think that you cannot be go for the patent first thing. Okay, and your idea, because sometimes we don't need to do the academic support for your idea. I hope you understand that now the startup is coming. The startup is not from the the professor and from the academician. The startup is coming from the new generation. So just you are here, you are representing the new generations, and you have the more than ideas from the faculty members. So you don't need to assist actually, understand. First of all, this is the things. And second thing
Yes.
is that for the innovation, we don't need to do academic background. Sometimes what will happen, something which is very unique on, sometimes if you will see by the common sense base, if you are changing into the, suppose I am giving the example of laptop. Okay, in laptop, suppose if you want to change the design, okay, this design is not good. If I will do like that, then maybe it will be useful for other persons. So what will happen? You done something. So that is also the innovation, and it can be also go for the patent. I'm not telling about the now the something very unique, something software updation or something like that, very big thing of the machine learning. But I'm telling that small things, because now I will give the one example of this agriculture based equipment. So you know that in agriculture now the everywhere we are using the sensors, okay, IoT sensors. So what will happen here? The things which is very normal in agriculture, just we are getting the automated by the using of the sensor. So here, if you are using a sensor into the agriculture process, same sensor if you are using the house appliances, same sensor you can apply into the everywhere, okay, in normal mechanical process, not electrical process. So everything can be go for the patent. Okay, so you can also go for the patent, first thing. Second thing is that in patent is beauty is that suppose you cannot be get the suppose Samsung will be apply for the patent, then Samsung will not go the patent for the television. I in first slide I clear that. So what will happen? He will just patent it from the different things of the television. Something he is creating the smart television, so he will go for the copyright of the IC, copyright of this something like that, something innovative. Then he will go for the utility patent. So same like that.
Sorry to interrupt you. Sorry to interrupt you, but we have to wind up the session because this link is going to be used by some important meeting.
Sure. So that is my suggestion. You can assist to the particular faculty also, but you can go into the your with your uniqueness also. You can take the guidance from US, but you don't need to assist to the any person actually.
Okay,
So that
sir.
is my
Thank you
opinion.
so much, sir. Thank you, sir.
So thank you so very much to the management, Ravin Pathak sir. Thank you very much for enlightening us and giving the in details about the patents and how to do the what are the difference between copyright, trademark, patent, and everything. And I hope in the coming time, all the participants, faculty members, students will come with the patents and this e-cell will have a lot many patents and the campus will have the patents. So whatever query you have, you can post us in mic@medicats.ac.in. We will resolve your query and आप कभी भी हमें contact कर सकते हैं. So thank you so very much. Special thanks to Ravin Pathak sir for sparing your valuable time and giving the insight about the patents and the KAPILA program. So thank you very much. All the participants are requested to fill the feedback form to get the certificate. Thank you so very much. Thank you everyone.
Thank you very much for this opportunity.
Thank you.
Thank you.
Thank you.